During the week, a United Kingdom judge dismissed the $6.6 billion award by an arbitral tribunal against Nigeria, which had risen to $11.5 billion with interest won by Process and Industry Developments, that is P&ID Limited, over a failed 2010 deal to develop a gas processing plant. Judge Robin Knowles of the Business and Property Court in London, which sat remotely and behind closed doors, ruled that the award was obtained by fraud and what happened in the case is contrary to public policy. The judge also found that P&ID had paid bribes to a Nigerian oil ministry official in connection with the gas contract and had failed to disclose this when it later took Nigeria to arbitration over the collapse of the deal. President Bola Tinubu applauded the judgment, saying that, quote, "Nation states will no longer be held hostage by economic conspiracies between private firms and solitary corrupt officials who conspire to extort and indebt the very nations they swear to defend and protect," and called it, again quote, "victory for our long exploited continent." Tonight, Tuesday Live shall be speaking with those who should know, but first let's get a background report put together by correspondent Anthony Forson.
The judgment came after 5 years, which has finally been settled to the advantage of Nigeria. The London court quashed the $11 billion arbitration award issued in favor of P&ID. The ruling, delivered by Justice Robin Knowles of the Commercial Courts of England and Wales, upheld Nigeria's prayers on the grounds that the ill-fated gas processing contract was obtained by fraud. The Business and Property Court in London delivered the judgment in the case between the federal government of Nigeria and Process and Industrial Development P&ID Limited. The federal government had initiated the development of tankers for the transportation of crude oil through the creeks of the Niger Delta, following the inability to fix the often vandalized pipelines in the region. However, P&ID had agreed with Nigeria in 2010 to build a gas processing plant in Calabar for the purpose. It failed and turned round to sue Nigeria, claiming that the contract failed because the Nigerian government did not fulfill its end of the bargain, saying Nigeria breached the terms of the contract and took a legal recourse and secured an arbitral award against Nigeria. On the 31st of January 2017, a tribunal ruled that Nigeria should pay P&ID $6.6 billion as damages, as well as pre- and post-judgment interest at 7%. Nigeria applied for an extension of time and relief from sanctions, which was granted by Ross Cranston, judge of the Business and Property Court of England and Wales. in September 2020, thereby returning the case to arbitration. With that development, Nigeria alleged that the gas deal was a scam conceived to defraud the country. Lawyers representing the federal government told the court that P&ID officials paid bribes to secure the contract. But P&ID denied the allegation and accused the Nigerian government of false allegations and wild conspiracy theories. In a March trial at the court, Nigeria alleged that the contract was secured through dishonest means that included bribery and perjury, and that the arbitration award, which has risen to $11 billion because of its interest, should be quashed. And it has been quashed. Nigeria stands tall in the case. Anthony Forson.
Thank you, Anthony, for that background report. We've been joined in the studio by Umar Hussein Babangida, Head P&ID Unit of the Economic, Financial Crimes Commission, EFCC. Thank you for joining us.
Thank you.
And Dr. Tunji Abayomi, a constitutional lawyer, is also joining us tonight. Thank you for joining us on Tuesday Live. In the course of the program, Dr. Minar Sarakogo, International Affairs Analyst, will be joining us, and also Professor Ken Ife will also be joining us in the course of the program. So let's get into the meat of the matter. We introduced you as the head of the P&ID unit in the EFCC.
Yes.
That means there was a problem.
Yes.
Let's get that problem.
Yes, certainly. An agreement was signed by P&ID and the federal government. Arbitration was entered, and award was made against the federal government, and there was an application to enforce the award. The government decided to look into the arbitration and the award itself on the grounds of fraud, suspecting that there could be fraud. What happened, what led to that? And the EFCC was directed by Mr. President, Commander-in-Chief of the Armed Forces, to conduct investigation into the circumstances surrounding the signing of the agreement. Now, most of the time we talk about 2010. Actually, the whole process did not start at 2010. And it is very important we understand the historical background so that we can be able to appreciate where we actually came from, where the red flag started, where the problem started. In July 2009, a memorandum of understanding was signed between a company, between Federal Ministry of Petroleum Resources and a company called Process and Industrial Development Nigerian Limited. The company was incorporated by the Corporate Affairs Commission, and it has Nigerians on the board of the company. One of the directors has 90% equity in the company. Then, fast track, 6 months later, in January 2010, the gas supply and processing agreement was signed with Process and Industrial Development Limited, a company incorporated in the British Virgin Islands. The question is that there is similarity in the name. Were they affiliated? No, they were not affiliated.
So how did was that done on purpose, for instance, and to perhaps do some kind of masking?
Okay, according to the CAMA, Company and Allied Matters Act, any foreign company that is to do business in Nigeria should be registered. P&ID BVI came in and then used the name P&ID, or Process and Industrial Development, of which is similar to Process and Industrial Development Nigerian. On the face value, you will assume that they are affiliated. But of course, by the time you unveil the directors of the foreign company and the Nigerian company, they are entirely different individuals.
Okay, so we signed a deal with the foreign company.
We signed the deal with the foreign company. But the MOU was signed with a Nigerian company. The question is that, how do they get connected? The connection is that the Nigerian director was not even aware of the MOU signed with the Federal Ministry of Petroleum Resources. Likewise, was not aware of the GSPA signed with the foreign company. So, red flags. Our investigation commenced from there. It couldn't have been. There should be an affiliation. There was no legal affiliation, no connection, then that is an indication of fraud may have started from there. We progress with the investigation. We ask ourselves, what was the GSPA supposed to achieve? What
For
was
Nigerians watching, GSPA.
The GSPA is the Gas Supply and Processing Agreement, and that was the focal point of the arbitration. That was the definitive agreement between the federal government and the company P&ID. The breach of the agreement led to the arbitration and the eventual award.
Dr. Ibrahim, we'll still come back to what Umar Hussein Babangida has been saying, but you will be wondering how many of these kind of situations have gone under the bridge without us even noticing some of these things. It looks as if it was a deliberate move, but what are opening comments on this?
The first and foremost, there was a problem as identified by the justice that decided the case right from the beginning in terms of the contracting parties. It was read through the judgment of the court. There were lots of irregularities in the process of contracting. And in addition to that, there was clear negligence of some sort. If I may just quote one of the issues that the justice noted, he said, and he was saying this in order for nations to pay a lot of attention to this contract, because that court actually saved the nation a great embarrassment. We're talking of an amount that is almost a third of the entire gross national product of this nation. How the nation, it would have been impossible to sustain development in this country with that kind of. The judge said, and I want to quote, he said, part of the problem is imbalance in contribution of parties, where experiences, expertise, or resources are grossly unequal. This underlines the importance of professional standards and ethics in the work of contract drafting.
Yes.
He was warning nations like Nigeria that there's a need to pay a lot of attention. I'm sure this must have been going on for quite a while. Part of the problem, in my view, is first, we have problem of lack of patriotism.
Yes.
Because if you are really concerned about the country, you will be on alert when you are talking of contracts of this magnitude. And you will also be watchful when you are dealing with external contractors like that. That's number one. The second point is that a whole lot of our people tend to pay too much attention to personal interest. If we look at the judgment of the court, quite a number of the leaders were bribed. 10,000 here, 5,000 pounds here. All of these were revealed. You are not talking of, you are working for the country in a very sensitive sector of this nation. You subjected yourself to be used. We even have a situation where the legal advisor became a witness. The legal advisor under that contract, for Nigeria, the lawyer for Nigeria became a witness for the foreign company. So how do we avoid all of this? I think our nation needs to spend a whole lot of time on institutional integrity. Institutional integrity, so that we can contain the appetite of people. And in our country, unfortunately, the leadership tends to have dictatorial tendencies. I would say illimitable power in terms of due process. Here, this is the difference between our country and most Western countries. You can see what is happening to Trump as an example. They said that our government may be a government of law and not of men. In our nation, we have a situation where a whole lot of time our government and our systems are of men, people, and influence instead of laws and process. That's really the nature of problem. And these things have been going on in this country for many, many, many years.
Let's come back to P&ID, and I'm interested specifically because having established a unit simply because of this. Is it a new entrant into the Nigerian system? Has it been on ground for a while? You've mentioned, something looking like Siamese twins. Closer investigation showed that the similarities are superfluous. So tell us a little bit about, the operations of the, company in question and its footprints in Nigeria.
Okay, the operators of P&ID are individuals that have been in Nigeria for a while, for over 3 decades, which means they obviously know their way around the system, and they apply for contracts here and there using different companies. For the records, the operators, they have registered about 30 different companies in Nigeria with the Corporate Affairs Commission, using different kinds of names. And then you discover they have equally registered over 20 different companies across the world in abroad. Some of these companies will have similar names with the companies registered in Nigeria. It's now became a pattern where proposals will be forwarded to government ministries, departments, and agencies using the Nigerian companies. But when it gets to the point of signing contracts or agreement, automatically the foreign companies take over and payments are made in foreign exchange. Now, the P&ID thing became almost the same pattern. But unfortunately, like Doctor has said it, of course, there are a lot of issues here and there, lack of professionals. For instance, a ministry signed an agreement to supply wet gas for processing into lean gas for power generation. The ministry is supervisory in activities. It is not operational in oil and gas.
Yes.
It does not have gas to supply. Who will have to draft that kind of agreement and give responsibility to the ministry? When you now look at it very carefully, you discover from the beginning certain things were inserted that made it impossible to enforce, to implement. That automatically indicates there is an semblance of arrangement to defraud the country. And our investigation, yes, the unit was formed in the EFCC to specifically look entirely into everything that has to do with the activities of the P&ID, to unveil who are the individuals behind, what do they do, what else have they done in the country, until we are able to discover several.
But have you, done contracts successfully in the country before, partially, or what amount of success have they done? I mean, have they made in terms of?
Of course, we should be familiar that more often than not, contracts will be awarded, and at the end of the day, whether it is completed or not completed, as long as payment have been made, it becomes story for another day. There are several contracts they have executed for MDAs in the country. There are some that eventually our investigation later uncovered. In fact, for your information, several of these companies are being prosecuted today in Nigeria. At least we have over 20 cases charged to court against most of these companies over money laundering, contravention, and violations of other extant laws, and individuals representing and partaking in the operations of these companies. So to show you that, yes, there were contracts awarded. Of course, most of these contracts may not have been executed completely, but the big catch will have been the P&ID contract, and that is why we are here.
Dr. Waomi, I don't know, but in your experience, many times when we embark on, undertake contracts like this, Are they not advertised? Do we not disclose because this is supposed to be in the public space? Why are we seeing some obfuscation in some of these processes in such a way that we could, at the initial stage, even be, have an award of $6.6 billion against the country in the first place? Not to talk of issue of going to court and all that. How did we get there? Did we not publish some of these processes?
The intention was actually good. The idea, Nigeria was interested in establishing a sort of a gas project. The idea is to ensure that the flaring of gas is converted to the use of gas instead of wasting it. And so they came up with this idea, which was actually a great idea. The question is, you now need performers in the process of realization of the objective. And that is where the problem lies. I think what happened was that the anxiety of the nation to create this great idea and turn deficit to benefit was simply taken over by negligence, as I can see it. Because if you look at the contract itself, it ought to have gone through a number of processes, and a number of institutional guides should have participated in looking at it. But it was limited to just a few people and a few, basically the oil sector. It didn't go to the Ministry of Justice. It was just a terrible situation. And then they entered into this contract without, some guides. For example, there were conditionalities, things that the P&I Process and Industrial Development Limited should have done in order to activate performance from Nigeria. All of this were not, put into consideration. Moreover, we have our own citizens who ought to protect the interests of the country carefully. They should have been anxious to do that. For some reasons, they were lackadaisical. And so the foreign partners just took advantage of the situation. And then, of course, there was also an arbitral clause that was clearly unfavorable, clearly very unfavorable. For example, the initial memorandum of understanding, it was stated there that the laws of Nigeria is to guide the contract. For some reasons, when the contract was actually made, it changed the terms, and a number of issues that was in fact in the memorandum of understanding was now different from the contract. For example, the laws of England now became the controlling law, contrary to the initial memorandum of understanding. You would expect that a lawyer working for the nation will compare the memorandum of understanding which had been signed by the two parties with the contract and say, look, this was not the initial understanding. So at the end of it all, in government, we need very alert people, efficient and intelligent people, patriotic people who are actually guiding the interests of this country. And that is where the problem lies, because we didn't have all these attributes in the process of contracting in this terribly embarrassing situation. If we look at what the governor, what the justice said, for example, he was talking of this problem of, I think he was talking at a point about corruption. He said it is common ground that bribery, you're talking of the nation of Nigeria. He said it is common ground that bribery was extensive in Nigeria and that some business could not in practice be transacted without it. But these points do not justify bribery. They reinforce the seriousness of a practice that threatens the foundations of a society. He was basically, and that is really what saved this nation. Yes. He saw situations of bribery, acts that are contrary to the Nigerian national interest, and public policy. And on the basis of that, he held that this contract could not be. These are things that should have been apparent to people that are acting for this nation.
You know, Mr. Umar Hussaini, you've seen this process, and Dr. Bayomi has, also alluded to it.
Yes.
In spite of the fact that we have, gotten ourselves out of this, intricate web that was going to, almost subsume the nation in terms of what it needed to commit to get itself out of here if we had gotten the judgment the other way. In spite of, how we have gotten ourselves out of it, luckily, there is still the albatross of corruption and patriotism in this case.
Definitely.
Because there is no way that a company will come and almost completely dictate its own terms. If you look at the contracts, dictate its own terms, how it wanted to work, and everything is skewed in its favor. And it seemed as if everybody on the side of Nigeria looked the other way for this process to sail through. In all this, your investigation, these red flags, would it help perhaps to further widen, this net in terms of future practices and perhaps other red flags, since we have signed hundreds of thousands of MOUs in the past, and perhaps that could help us retrace our steps when it comes to drafting these contracts and also making sure that our own officials are accountable as well?
Yeah, definitely it will. And you see, going back to the P&ID agreement, there are 8 other companies that equally signed similar kind of agreement with the Ministry of Petroleum Resources for the same processing of the gas. Now, based on that, we advised the Ministry of Petroleum and even the NNPC that henceforth release all the details of those agreements so that we will review them and ensure that proper procedures were followed. First of all, there should have been Federal Executive Council approvals. There should be the ICRC, Infrastructure Concession Regulatory Commission's approvals. There should be the Bureau of Public Procurement approvals. There are several processes. Ministry of Justice ought to vet and approve the agreement, because the director or the director of legal of each ministry is automatically a representative of the Attorney General of the Federation in that ministry where the director is serving. They are supposed to vet and forward to the Ministry of Justice such draft agreement for vetting and approval before they are executed, where all the I's and the T's will be dotted and T's properly crossed before it will be okayed and then executed. But you discovered all these were not done. The question is, was it inefficiency? No, I don't think so. It may have been an intentional act to create. Like the doctor has said, it was the gas development project was a low-hanging fruit, such that gas flaring will be reduced, the wet gas will be converted and processed and used for power generation. But somewhere along the line, lack of professionalism, the greed of individuals, our lackadaisical attitude, and so many other factors, I believe ministers and senior officers may have been misled into believing that the agreement were perfect and ready for execution, and they were executed, only to discover. I think all this, we need to extend it to other ministries, departments, and agencies. That is the focus behind the creation of, in fact, the unit, P&ID unit, so that it will specifically concentrate on this matter. At the end of the day, come up with range of recommendations that will be able to guide the government, ministries, department, when policies are being put together.
Just while you were talking, Dr. Menasra Kogo, friend of the program, international affairs analyst, just joined us in the patriotic green, but it's a bit on the lemon side. But thank you very much for coming.
Thank you.
I saw you frowning just while you were entering. Perhaps the scenario created by, drawn up by my panelists, perhaps took you aback a little, looking at what played out.
Well, first of all, I would like to appreciate the judgment delivered by Justice Robbins, first of all. But most importantly, I would like to appreciate two groups, civil society groups, and the media, especially the social media. The trajectory of this matter started around 2009, and the civil society groups and the media kept the nation on its toes, kept talking about this matter. Up to this moment, based on my personal investigation, I think about 18 Nigerians are involved. There are corporate groups, bodies involved apart from the governmental agencies in this. So what Justice Robbins' judgment has done now is on the torchlight and then give you a mirror, say, look at yourself.
Yes, it's true.
Look at yourself. Paradoxically, you may think, yes, there are memorandum of understanding signed, which, like Dr. Abayomi said, modified. But whether you modify memorandum of understanding or any contract in whatever form, the standard international law is lex loci celebrity. That is the law of the domain, the law of the place where the contract will be executed prevails. Yes. So if you like change contract into so many number, the law of the where it should be executed prevails. Now this was a bogus something that there will be a gas company in Nigeria, which ultimately there was failure in execution of it. And then in the MOU they said, irrespective of whether there is failure or not, so money should be given. And at the end of it, when it was given, when we went on appeal, they were even demanding for a continuous calculation of interest. Another this, which by that calculation it should even have been higher than that quantum that we are talking about. But the dexterity with which the civil society grows, and then foremost statesmen, I must commend Dr. Tunji Abayomi. He was one of them that doggedly stood for this matter. We now said two things must happen. There must be stay of execution of the order they got. And then number two, when we eventually had, the agreement should be thrown away. In other words, the award should be jettisoned. And that is what we have now gotten. Now, why I call it a torchlight and a mirror is that this should be the beginning of the matter. Yes. Our relevant authorities must dig deep into the district, bearing in mind, under Section 15, subsection 5, the state must, because the word shall was used, must fight all forms of corrupt practices and abuse of office. Yes. So it is an emphatic duty. And then for those citizens that are involved, there is even somebody that even apart from himself, even his son was there, just by virtue of biological accident of giving birth to him. He too has a share of what should be given to him. The A to Z of it must be investigated. These things have been going on for long. Yes. Remember the case of how we lost Bakassi. Yes. The Green Tree Agreement of 10 years for us to appeal. The lackadaisical refusal for us to appeal against it led for us to lose Bakassi. 10 good years for you to appeal, we didn't appeal. And there are several of these type of things whereby, disgruntled citizens will have it in connivance with the governmental officials, because this is not something that it is beyond a matter of floating a company. Yes. It is something which symbolically is a matter of entrenched tradition. Several governmental enterprises is like that. So much so that now it has even become a practice in our budgetary provisions. There will be provision for litigation indebtedness or judgment debts. There will be provision for that. And then the government will keep paying. So we must be prepared to really unveil the decision. Fortunately, President Bola Tinubu has fight against corruption in one of his 8 points agenda. What is the 8 point agenda called? Renewed hope. Renewed hope. So this is the litmus test for us to see whether or not this assistance, this gentleman Justice Robs has given us, we will exploit it to really do the internal cleansing of our own institutions and of our own officials. It should never be left to be swept under the carpet. This should be the beginning of it. That is my take, sir.
We are just getting to the meat of the matter, and just while that was on, Professor Kenife also joined us. Prof, thank you very much for joining us.
Thank you for having me.
Of course, you must have been listening to the discussions and the favorable judgment we got as an economist. You know what that could have done to the economy if we were compelled to pay 11.5 billion dollars as it were. But you know, we are happy that did not happen. But first of all, in terms of just what it could have cost us and what it even cost us in terms of even the embarrassment, international embarrassment. What are your thoughts, your opening salvo on the program?
I think we still have to come to terms with what it would have cost us if today gave the other judgment, if it was against Nigeria. What you would have seen would have been an assault on our sovereign rating. All the Standard and Poor and Fitch rating and Moody's, they would have downgraded Nigeria to junk status. Because already JP Morgan has said that we only have 3.5 billion in our foreign reserve, that all the other ones are committed. So immediately they will say, well, if you take away 10 billion from the 3 point, there's nothing left. So you are technically bankrupt. So that would have been a massive disappointment. And then you know what happened immediately, it will be more difficult for us to borrow because the rates will be, through the roof. But if you look at that quantum of money, that at the rates, at the benchmark rate for the budget, 2024 budget, which is $1 to 700 naira, that is 7.7 trillion naira. And if you divide it by 200 million Nigerians, it's about 38,000 per person. Or if you look at 20 million Nigerians, families, then you see it's almost just under 400,000 naira per person, per household. So it's a lot of money by any standard. And if you look at that money, is equal to the personnel cost in this budget. Because the personnel cost is 7.8 trillion, and this is 7.7 trillion. And it's way higher than the capital budget for the whole 2024. So the impact would have been massive. And then if you put it to GDP, is even almost the same as the service cost for debt service. So the impact would have been something else to the country, but we thank God. And then even if you had to pay that money by raising an instrument, and then you have to, that instrument will be for 10 years, then take 7% of that instrument over 10 years and add it to the 11 billion. That will be much higher than that money.
Dr. Bayomi, I look at the boldness with which some of our officials go about some of these processes, and sometimes we wonder, are we in the same planet? When you look at these figures, where the cold stack figures that have been put in front of us by Professor Ife, and in your agitations and your pushback, especially in these processes, what would be your word to the EFCC? First of all, in terms of perhaps we may need at some point in Nigeria to begin to name and shame. it seems to me as if it's getting to the point where a lot of times we just push these things away. We are happy, we celebrate, we beat some drums and agree with Professor Kennefe that we're out of it. But sharks and hawks are still waiting in several ministries and MDAs with some of these bogus MOUs. Some have even succeeded, and perhaps some have, have gone away with it, retired and all that. How do we begin to, you look at, interrogate these processes, perhaps even roll back the years to start from somewhere and get this table clean?
Well, my view is that anti-corruption should become what I would call a culture. The EFCC is clearly overwhelmed by the challenge, in spite of all the effort it's making, as you can see in this particular instance. But I think there's a need to create, whether we call it due process agencies or system, or some form of reportage that is not subject to institutions, but some kind of monitoring. Because as it is now, if we have, for example, this kind of agency in this kind of system, they could have alerted appropriate agencies or appropriate ministries like Ministry of Justice, or even institutions like EFCC, of this type of situation. But in the midst of this, it's also important to commend the last government, and that is President Buhari, because there was a lot of pressure for him to pay, particularly after the arbitral award. We had a situation where, for example, the beneficiary of the arbitral award was the one that was actually pressuring the government to pay. I mean, ideally, you wait. If they do not pay, you take action. But he was willing to negotiate and do everything. But the government of President Buhari refused and insisted that it wasn't going to pay. And then demonstrated some form of courage in actually going to court to challenge. Because ideally, the norm or the normative is that once there's an arbitral award, you expect that it will be executed. Usually, a court will affirm an arbitral award, except in situations, there must be an egregious reason why a court will not do that. But in this particular case, we're just very lucky. Because as the judge said, he said, the arbitration, in this particular instance, he said the arbitration was a shell that got nowhere near the truth. He said it was a shell that got nowhere near the truth. This was an arbitration. We are talking of an arbitration of 2 foreigners and 1 Nigerian. And the Nigerian barely had the possibility of doing anything in favor of the country. It was held in London. So you can see the problem. There's a need for some kind of government to stand on this particular issue. I think it's about Einstein or something, who said if I can see further than others, it's because I stand on the shoulders of giants. This is a giant case that I think the government, the federation, should stand on to create some kind of system to monitor expenditure, not just only on contract, expenditure on behalf of the people. Because government is to serve the people, and the people cannot be happy with the level of negligence that we see. He's talking of a simple example of Bakassi. The level of negligence and just disregard, lackadaisical attitude, as if government work is just anything. That is the situation we have. Whereas you see in Western countries, especially, government work is considered the most primary work because you are serving the people. So these are the sort of things that I think we need to input into the system. Like I said, There is a need to create institutional integrity, system of institutional integrity in a country that is able to contain and control illimitable appetite of individuals for corruption.
I did a course, in ASCOM Badagry a year or two ago,
yes.
And there was a particular session. They were saying how to manage difficult officers.
Yeah.
I disagreed with the lecturer. I said the definition of difficult officers was the one that you found difficult to manage. But in our case, it's getting to the point that it is the officer that insists on doing the right thing.
Yes.
These days.
Yes.
They see them sometimes as even the clog in the wheel.
Yes.
Somehow, if you insist on due process, how can we get to a situation where all these clauses and all in the contract, people look the other way and got to the point where we got ourselves in the point that we needed to almost pay 11 billion,
yes.
To a company for a job that was not even done in the first place. Doctor.
You see, if judge that decision was upheld, the monumental disappointment against the nation. For example, you can get garnishing order.
Yes. Yes.
If our liquidity position at the foreign reserve is not sufficient, they begin to attack. How would you can imagine the embarrassment? A presidential jet will be attached somewhere in one country.
Oh, the embassy.
You understand? Our embassies.
Yes.
So many. But coming back to your question, we will be able to get things correct if the government is really up and doing. Mm-hmm. There are certain institutional mechanisms that should be in place. The first one is that whistleblower should be there should be a law to establish whistleblower. Yes. There should be a law, there should be a particular listing to give protection for the blowers. We are only singing about whistleblowing. Mm-hmm. Up to this moment, it is wrong for us not to have institutionalized it as a legal institution, whistleblower. The second aspect is that now that His Excellency the President is making so many appointments, how many have complied with the Code of Conduct? From 1999 to date, how many of the public officers has Code of Conduct Bureau investigated and penalized before the Code of Conduct Tribunal? How many landmark cases have we seen before Code of Conduct Tribunal, which is established under Section 153 of the Constitution and in the 5th Schedule of the Constitution? That is the only court on the land that is not subject to any interference, because it can ask you to vacate your seat. Whether you have immunity or not, it can ask you to vacate your seat. It can ask you to be barred from holding public offices for up to 10 years. It can ask all the illegally acquired money to be liquidated into the nation's treasury, and so on and so forth. Why is it not effective? How many people have we seen facing the music? Something should be done to revive or revitalize it. Apart from that, the other area I am seriously worried has to do with, before you give anybody that appointment, he must be able to fill the Code of Conduct form. You must be able to show by example. Otherwise, you will not be able to ask employees under you to go and comply with the Code of Conduct requirement. Another fundamental thing is that Section 304, Section 3, I'm talking about the judicature. Mm-hmm. You understand? Section 204 to 304 of the Constitution should radically be amended, so that we should be able to institutionalize National Anti-Corruption Court. It should not be this type of regular courts. It should be a court of summary trial. Any matter that reaches there, give it maximum of 6 to 8 weeks to dispense justice, so that it will not be treated based on the normal technicalities we have in our regular courts. It should be a special court of summary trial that will be dealing with corruption cases. EFCC, the frustrations you people are getting under the normal procedure in our district should be reduced. And apart from that, there should be leadership by example. Personal discipline is very, very important. If a country that is getting out, borrowing money here and there to be able to pay salaries and meet up monthly obligations, and then you are going into voodoo spendings, so billions, so trillions for luxury things. Naturally, the citizenry would not take you as somebody who is really a symbol of fight against corruption. Like Dr. Tundi said, it should be institutionalized, it should be in our own steels. Because under sections 21, 23, and 24, every citizen is under obligation to support national programs of the government. And under that, fight against corruption is one of it. It should be part and parcel of our decision. But we should be able to make it as a way of life. In other words, we should be able to tally it with our customs, our culture, our tradition, as per section 21 of the Constitution. And we should be able to do it in such a way that right from schools, children are modeled towards good conduct, good citizenship. And at the end of it, religious bodies, traditional institutions, everybody should really partake.
We will come there,
yes.
Dr. Kogo will come to, what to do. We just established the problems and perhaps some of the, issues that EFCC has been trailing.
Yes.
But before we go, we'll come to EFCC just shortly. But let's take this report from Abuja still on this case, and then perhaps that will set the template for the next leg of our discussion.
Yeah. We'll strategize on how would ensure that the enforcement is set aside and we get leave to appeal the case. We also intend to change narrative by visiting the major media houses, financial institutions, to let them know the true narrative about this P&ID contract, and the fact that it's more than it's been falsely circulated by the P&ID people.
This was the beginning of Nigeria's pushback when a high-powered delegation arrived in London to begin the canvassing for the London Commercial Court to hear the Nigerian side of the story. 5 years down the road, victory has come the way of Nigeria. When the Nigerian government moved in to contest the judgment against her by the London court, little did the Process and Industrial Development Limited, P&ID, understood the grounds Nigeria was coming from. The UK-based firm successfully believed it has taken the day, but Nigeria was well armed with all the facts to convince and upturn the judgment.
That judgment that was delivered by the London court will be in the annal of our history as a judgment that has emancipated Nigeria from the hands of criminals who just use their complaints in their briefcases and come to the country, sign an agreement, take advantage of it. So I am so happy. It's a joyous mood for me as a Nigeria that is patriotic, seeing that at the London court gave a judgment that is justiciable.
With this judgment, what does it translate to?
In this case, how we deal with people who are coming to seek for contracts of billions of dollars in Nigeria is for us to prepare for them. How do you prepare for them? Ensure that you give them stringent conditions.
Are there lessons to be learned?
The lesson for Nigeria is that the Federal Ministry of Justice has the, what can I call it, has an obligation of making sure that all the agreements that we're going to sign with any foreign company will not tie the neck of Nigerian nation.
Whichever way the judgment is viewed, there are highs and lows, as Justice Robin Knowles equally cleared one of the counsel, Mr. Shasori, son of non-complicity and of corrupt character. Anthony Forson.
Thank you, Anthony. That was the former Minister of Information when for the case in the United Kingdom, and like he said, when the pushback started. You must have also, given some information to the team to help, put this case together in terms of when we were, trying to prepare our own case as well.
Yeah.
In all this, what were the findings that perhaps you could see as a breakthrough, which led us to this point?
Okay. I was equally in the team that went to UK at that time. And what we did was a forensic analysis of all that had happened. And at the same time, looked at all individuals that had played one role or the other and review the processes and the roles they have all played, which we discovered that the individuals that, for instance, the lawyer that drafted the agreement had a long-standing relationship with the owners and operators of the P&ID for a very long time.
Who drafted on the part of the government?
Definitely, yes. He's a lawyer, he's a legal director at the Ministry of Petroleum Resources, had a long-standing relationship with owners and operators of the P&ID. In fact,
made to her children.
Definitely. In fact, 11 days to the execution of the agreement, payment was received by one of her daughters through a foreign account from one of the affiliates, associate company of P&ID. That goes to tell you that there is a relationship.
And even after.
And the relationship. Now, I'm taking them one at a time. There are several other payments that we have traced, not only to that individual, but to several other government public officials. That to show you that the whole process was a kind of a scheme to outsmart the government. It was a noble idea from the start, but it was wrongly handled. And of course, unfortunately, maybe wrong individuals found themselves in the right place, and then the wrong things were done. So we have to take a forensic analysis of all this. We have to juxtapose. We are not only looking at P&ID as the focal point. We look at all associate companies and individuals that are connected, and we unveil all the identities of the operators of all the 30 companies registered in Nigeria. We equally look at the forensic analysis of the foreign registered companies who were registered in the British Virgin Islands, Isles of Man, in several other companies with account in Cyprus and other tax havens. We now we synergize with, of course, intelligence agencies like the NIA, the NFIU, the Interpol. We got a lot of volumes of information. We got hundreds of thousands of documents which we reviewed to be able to arrive at who plays what role, who is behind what, who stands to benefit from what, and then juxtapose all the information together and arrive at the entire picture of the scam. That in 2019, last quarter of 2019, first quarter of 2020, we are able to now file an appeal against the execution of the award. Eventually, Justice Ross Cranston granted the application, and eventually he established that Nigeria has been able to establish a prima facie case of perjury against the only witness of P&ID during the arbitration. That is late Michael Quinn, which is the co-founder, one of the co-founders of P&ID. He established a prima facie case of perjury against him. He established a prima facie case of fraud against P&ID as a company, and of course a prima facie case of dishonesty against one of the lawyers that represented Nigeria in the arbitration. So there was a group of several activities that were carried out before the award. During the arbitration, there were a lot of other activities that have taken place. For instance, public officials were being compromised, classified documents were being obtained from the ministries, which were being used against the federal government during the arbitration.
Of course, supplied by Nigerians. Let's quickly go on a break. When we return, we will continue with the EFCC perspective of the case.
The counsel of our fathers.
I will urge and advise our younger generation to use talent and brain to sort out problems, not arms.
Nigerian youths, let's build our nation.
My advice to these young people is please do not take us those harrowing days. You probably do not know what it is.
I believe we have fought one civil war too many in this country. So those who experience it will run away from it.
Nigerian youths, let's build our nation together.
NTA Tuesday Live, a network issue-oriented innovation talk show.
It's watching Tuesday Live, and just to keep you up to speed on what we've been talking about during the week, a United Kingdom judge dismissed the $6.6 billion award by an arbitral tribunal against Nigeria, which had risen to $11.5 billion with interest, won by Process and Industry Development, that's P&ID Limited, over a failed 2010 deal to develop a gas processing plant. Judge Robin Knowles of the Business and Property Court in London, which sat remotely and behind closed doors, ruled that the award was obtained by fraud, and what happened in the case is contrary to public policy. We'll take your calls now on this, your take on it, and of course, yes, it's P&ID, but it couldn't have happened without, somebody in the house also helping the stranger to climb the fence. But we would take your calls now. The panelists will also respond to your take, while EFCC will continue to help us put things in perspective on this quite laudable job that you and your team have done so far. And, it's good to also commend you at this time for even, establishing that unit simply for this process. And we've seen now that it has led to a landmark judgment that could shape in the future of our, processes in terms of monitoring this, processes. Caller is on the line. Caller, can you give us your impressions and make your comment on Tuesday Live? All right, I understand that we just missed him. Caller, we are waiting for your call, but you were trying to make, a comment, Mr. Hussein Babangida, talking about how eventually we got to this point, especially your interventions in the United Kingdom.
Yeah, during the United Kingdom campaign, we visited several media organizations to enable us tell our story, so that they will understand our own perspective, and then of course interacted with several media firms to be able to rub minds. And when we got back to Nigeria, we looked at the roles played by different individuals, both the foreigners, the Nigerians, public officials, and then it was a decision that has to be taken. Whoever that plays a role has to dance to the music. We filed criminal charges. The first we did, we filed criminal charges against, of course, Process and Industrial Development established in the British Virgin Islands. We looked at there are several contraventions of the money laundering law, miscellaneous offenses, tax evasions, and so on and so forth. We filed criminal charges. And also we filed criminal charges against Process and Industrial Development Nigeria Limited, because we discovered that several transactions were being carried out under the name of the company. And the company, under the money laundering law, it's a designated non-financial institution by the nature of activities the company is registered to carry out. And
all right, let's just hold that up because Umar has been on the line. Umar from Benin Kebbi. Umar, make your comments on Tuesday Live. Umar, you're on.
Hello, good morning. Yeah, good evening.
You're on, Umar, yes.
Umar, and I would like to congratulate all Nigerians for the job well done. And I would like to thank the Business and Property Court in London for doing justice to this topic. It's really indeed a remarkable achievement. This is where we say the presidential committee, the president needs to establish a high manpower presidential committee that will review all the contracts signed, particularly with foreigners at individual capacity and companies, to review all the contracts. And I thank God my nephew Umar Kogoi is very new place. There are several cases of corruption, endemic corruption in Nigerian cases. I want to appeal to President Bola Tinubu to kindly establish special courts on corruption cases. This is very, very important. And in doing that, please, let's change our presumption. Let us presume anybody that is tried under this court, let him presume to be guilty until proved beyond reasonable doubt that he is innocent. It is very important. And finally, I want capital punishment assigned to those corrupt cases. Just like China wants capital punishment on corruption cases. That is why corruption is reduced in China. It's equally reduced in Nigeria if capital punishment is assigned to corruption cases. May God continue to bless our country. Thank you very much.
Professor Ken, you listened to some of the, in terms of the implications. Those days when one was growing up, we just used to say jokingly, when you see somebody that's a bit dishonest, you say, you can sell the country. But apparently we have people who could actually practically sell the country.
If you read the case, the judgment, something that strikes you is the imbalance in the contract, drafting of the contract. That imbalance was already was caused by bribery and corruption.
Definitely.
And the second thing is that there was no real intention to execute a contract. The intention was to create an instrument which they would take to a tribunal to get an award. That was the intention. And the judge actually brought that out. And then some of the evidence was the document being pleaded for the EPC contract was actually detailed drawing of the job that was done for a different
company.
So they never really wanted to do anything.
Prof, just a moment, if we can just take Sunday from Kaduna. Sunday, you are on Tuesday Live. Good evening.
Good evening, sir.
Go ahead.
Seriously, I'm happy with what is happening. But the thing is, there's serious happening in Nigeria. In fact, the internal corruption is more than the foreign one. So if our leader will really be needful, I believe will be more than that. I just had a rumor of what is happening in this agricultural loan, that they will collect a lot of names from the farmers, and one man will sit on the money without giving it to the real farmer. That's one sector.
Hello, Sunday? Okay, we lost Sunday, but of course you've made your point. Prof, you were talking about the fact that there was no intention to even execute the
designed to be executed. So that was why when they were arguing their case, the judge is going to the High Court gave the opportunity disclosure, and which was the difference that the judge actually brought out, because in the tribunal, they didn't have the depth of the disclosure, and particularly where a state is involved, because there are issues of public policy that were at the base of this. It wasn't designed to fulfill or meet the stringent requirements of our public policy. Our procurement are going to FEC and going to review the contract by the Attorney General. So all of those were intended to be sidetracked. And there was no intention to actually do it. Even if the contract went through all that, the intention wasn't there to actually do the work. So the document they were abandoning was the work that they did for T.Y. Danjuma. So, and then the level of corruption wasn't just one party. Officers, lawyers, the tribunal people. So it exposed all that level. And so what that brings out is they have to review arbitral proceedings, especially where a state is involved, so that you can get, okay, it wouldn't be a big issue if you had discovery, or as you would have, a disclosure and discovery as you would have in the High Court, then it wouldn't have been an issue that they leaked document, because any material that is relevant to the case would have to be discovered.
Yes.
Do you understand? Yeah. So he brought that issue. So, and again, he also looked at the law as it relates to when an arbitration award is given. Under what circumstance will they appeal and get the High Court to look into the detail? You brought issue of corruption, all kinds of things that you threw at them, forced their arms, so they had to look at those. And it was really good that they did.
Let us take a leave from Maiduguri. Are you on the line? Are you there?
Yes, I'm on the line.
Go ahead, please.
Congratulations to all Nigerians that we are celebrating this success. But we have much to do. Much more than this one to do, because what is happening in this country, as if corruption is legitimized, because some people don't even know that what they are doing is corruption. So EFCC, they are doing very well, but EFCC have very little personnel to manage the corruption of this country, because what is happening in even one state in this country is not is beyond the capacity of the EFCC to overcome. So EFCC should be expanded, and they should be given a special court that they will take these cases to, because the cases they have in one court in Abuja, if you count, there are so many. So I want a country where we have a special court for the EFCC. Then the EFCC should be everywhere in every local government. And they have special courts in all the 774 local governments to try any form of corruption. And there should be a special academy for the EFCC. Let them take children from the age of less than 10 and train them throughout, and let them indoctrinated that they are here to fight corruption. So if things like this is done, and the punishment for corruption is made that if anybody who is found to amount of that money, then he should be maybe hanged or even life imprisonment. Because sometimes you just they collect the money and they release the person to go. Then people will do. It is encouraging people to do this. Is it a fair bargain or what? Something bargain they are saying. Bargain. That one that if you corrupt 10 billion naira, you now come and negotiate with them and give to the federal government 5 billion. Then you go away with the 5 billion. People will be encouraged to do that. Even those who do not have intention to be corrupt, they will be corrupt. So please let us look at that angle. Thank you so much.
Thank you very much for your call. Dr. Bayomi, Nigerians are making, their contributions. You have been at the forefront of this fight, this pushback. A lot of people today just listening to comments and looking at some comments on the social media as well are saying that P&ID is just a tip of the iceberg, that there are even Z&ID somewhere underneath. What are your comments at this time?
Well, I think one important aspect, I think my colleague has spoke about it, to give protection to whistleblowers. It's some kind of. I have a case a few years ago of a lady from I think Kaduna, who was in is it Shorty or something, some kind of program.
Shorty?
Shorties, I think it's a Shorty program, in which there was this contract that was awarded. I think it's with regard to the planting. We used to have mango trees along the airport road before all these roads were created. And at the end, this idea of replanting those trees came up. Some kind of amount was put in it, which was blown up by a very powerful force in the presidency. And then money was paid, and then the woman, then there's, again, for the little that is left, the same person who took all this money sent in individuals. Because you see, in a country, money gives influence, influence gives protection. So, and the lady stood up. The guy said, "Oh, I'm from this person." And then the lady said, "How about Nigeria?" But the problem is that individuals who are courageous to stand up, they are never sent abroad for programs. They are never promoted. They are never encouraged. At the end of it all, this lady had to leave the government because the frustration was far too much, because she could not, in her conscience, support the level of corruption. This is the type of experience. In our country, we have a situation where it's the guilty that prosecutes the innocent in our system. So if we look at what is happening here, now, this is what is said about, they said that company, is a contract was entered into the British Virgin Island company with no apparent asset. This is in the judgment. No apparent asset, no obvious industrial experience, no other credentials to suggest that it will be suitable to operate such a sophisticated arrangement. Now, if you are bringing in your money into the country, of course, maybe some kind of liberality can be allowed. But if we are going to put our money to assure some kind of project for our people, it will seem reasonable that there is some form of investigation to ensure that the person or the institution or the company to which we are committing our money is suitable. Moreover, some kind of guarantee for us. So, in the absence of all of this, all of which is actually the endemic problem of our government, I think that with this experience, in my view, our government needs to wake up. Because when you come to see the problem of this country, why are we where we are today when you should be in the forefront of development? All the countries that were co-equal to us, something like about 40 years ago, have all advanced beyond, and we are still down below. India, South Korea, Malaysia, and so on and so forth. Look at where we are. Why are we where we are? We are where we are because the resources of the nation is not properly. And if you consider the wealth that God Almighty has given to this nation, it is rather unfortunate that we are where we are.
Abdulatif from Ilorin, are you still there on the line?
Yeah, I'm there.
Please.
My credit level is back to running now.
Sorry about that. I apologize. Please go ahead and make your comment.
Yeah. Thank you very much. Good evening, gentlemen.
Good evening.
I'm very sorry to say I've had some people who have passed comments on congratulating Nigeria. I think what we have to discuss is more than just sending words of congratulations. We should be weeping. My heart is bleeding. My heart is honestly bleeding. I wonder what kind of people we have as representatives of government, people in top government places who are just ready to milk the country, to mortgage the future of generations and upper generations of Nigeria. It is very, very unfortunate. Our constitutional man there has said something that there should be a summary court. I don't know what he called it. A court for summary trial should be established, set up, so that people with this criminal tendency could be summarily dealt with decisively, promptly. I think I heard too that about 18 Nigerians or so have been involved in this. And people have also passed comment that this is just a tip of the iceberg. I think this situation is an eye-opener. There are so many other things that are going on under the work. Some time ago, I was reading a book. There was this case of one Jefferson from either the US or something. If you take a dress, look back at that Jefferson case. It's just similar to this. Nigerians are so bad in places, and we are ready to even sell this country with impunity. I don't know what is happening. In fact, I lack words. I don't know how to describe the situation again. We should be weeping. We should be crying. We should all go out after these hoodlums, get them arrested, prosecute them, punish them, capital punishment for them. Long live Federal Republic of Nigeria. It's very sad. Thank you.
Thank you, Abdulatif from Ilorin, for your comments, and we apologize for keeping you on the line while Dr. Abayomi was making his point. Minister Akugo, you've spoken about courts and all that, but yes, it seems to me as if some of these people are already set in their ways. In terms of recruitment, in terms of putting people in positions, you talked about the code of conduct and all that. But is there a process, that people can, we can have in from states and local governments, that people can actually come and commend or object to some positions of, sensitive positions when, people are given these positions, and then we can, before we even, let them get started or sit down comfortably in those seats?
Yes, a fish gets rotten from the head. Yeah. The leadership in the country must be prepared to restore three things: statesmanship, history, and culture. Statesmanship simply means ability to recruit competent statesmen, people that are prepared to die for Nigeria. Not people that will come into Abuja in taxi and after 4 years they get graduated into celebrated owners of private jets. Not people that will come and be squatting in Dr. Abayomi's boss quarters. But after 4 years in their respective offices, they turn prestigious owners of mansions in Asokoro, Metama, and Lekki Peninsula. Not that time. And we should do it by changing the political culture. A political culture that makes that for you to be a presidential candidate, you must be prepared to dole out 100 million naira, which is more than 4 times of the president's genuine salary. It's an anathema to our history and our custom as a people. Nigerian people must be prepared to take the laws and correct things by themselves. This gentleman, the judge, like I said, on the torchlight and gave us mirror. Look at yourselves as the nation and see how inwards you can correct. The system of political recruitment must be changed. A leader must be prepared to be the last to enjoy and should gallantly be prepared to present himself as the first to suffer. That is leadership. And we want to see leaders whereby when the national anthem is being played before them, tears will be rolling down their cheeks, because you know the meaning of every letter there, every word there. Or when you are being administered with oath, you should be prepared to be crying. The number of words there and their meanings there, whether in the respect of the religious books or in respect of statesmanship as a nation, should be prepared to really shake you. Not somebody that will be accusing you, say, I didn't see advertisement, you congratulating me in the office. Rubbish. If you are being given an office, you should be prepared to cry. So the magnitude of what will be the wrath on your head, that should be the lining something. Until we evolve leaders with these type of three qualities. Leaders that are prepared to be statesmen. A statesman is somebody who is prepared to leave good name, so that he will be remembered in the next 50 years, 100 years, 1,000 years. People like Mahatma Gandhi that didn't die leaving any affluence.
Dr. Miraso, let's just allow David from Abuja to come in so that we can remember him after this program.
Okay.
David.
Hello?
Go ahead, David.
Yes, good day, everyone. Thank you very much. It's really essential. It's been a while I came on to this line. Yeah, but my concern is basically people who are involved in this criminal activity. What is going to be the action on them? Because we have just been talking here about this is what we have to do for Nigeria, this is what we need to achieve and all. How are we going to penalize these people? 11 years ago, the Vice President himself was also on this particular Tuesday Live. I'd like to tell you, we have had prominent people who have been on this Tuesday Live. And most of those prominent people also have resorted to be people who we feel or we have heard or had a hearsay that they are involved in corrupt activities. I'd like to tell you that over the Tuesday Live, basically, what is the action steps that have been taken after the Tuesday Live? Also, one other concern is the fact that do we always have to have our country being penalized by international countries? What is wrong with our own tribunal, our own code of conduct, and all which we have spoken of today? If so, then maybe we should take all our criminal activities to international countries so they can actually penalize people for us if we cannot penalize them. Thank you very much.
All right, let's, David from Abuja, thank you for your comments. EFCC, what are you doing beyond presenting our cases and our case and what you have found out? What steps are we taking beyond that?
Okay, so far, you know that criminal justice system is not a one-way traffic. It's not just the law enforcement that is involved actively in the criminal justice system. We conduct investigation, prefer charges, file charges in court, and allow the court system to run in its own process. And that we have always done, especially in this instant case. Earlier on, I was telling you about the companies we have filed charges against them. They have been convicted by the court. And the penalty was the companies should be wound up and all assets of the company forfeited to the federal government based on the nature of the charges that were filed, including the Process and Industrial Development Company in the BVI and the Nigerian company. All their assets are to be forfeited to the federal government. The award, if for instance we had gotten an adverse judgment, all we needed to do is to register the conviction in British Virgin Islands, in the United States of America, in the United Kingdom, for them to be recognized. We will, by that, recover the entire asset of the company, even though there was little or no asset in the first instance. The only asset that P&ID has was the award.
Yes.
And if you again go back to what Prof has said, what Doctor has said, you discover that the project itself, the agreement, that is the GSPA, was never meant to be executed. For instance, P&ID was to establish a processing plant somewhere in Calabar. In the agreement, it claimed that they had a 50-hectare land given by Cross River State government. Our investigation revealed that there was no land. They couldn't have built any processing plant. It was false. It was false representation in the agreement.
All right, let's quickly take Tukru from Kaduna. Tukru, are you there?
Yeah, I'm here.
Go ahead, please. Go ahead, please.
I want to say thank you and well done for the job well done by the EFCC.
Thank you.
And all those that are involved. And it is a great success for our nation. But my take here is, the EFCC have said that all those that were involved, the officials, are supposed to be prosecuted. I'm a retired person. My advice is that all contracts that are being signed by the various ministers with external companies, even with the Nigerian companies, should be sent to EFCC for vetting. And the due process office should be reinforced, because the issue of getting no objection of all these things are being abused. So, and unfortunately, because of lack of patriotism from all the most of Nigerians, you discover that person is ready to compromise the whole nation for his selfish interest with his foreign connivance. And I think there is need for the reward system in Nigeria to be reviewed. Because most of this, you discover that a whole director in a ministry earns just about 500,000 naira. And for heaven's sake, if somebody comes with $20,000 and given to him, he will entice him because there's no patriotism. So we thank that the government, the previous government that has shown interest to pursue this case to the logical conclusion, because it was all fraud right from the word go. Thank you and good night.
Thank you so much, Tukur from Kaduna. Thank you very much for staying on the line. Please round off your point so that I can go to Dr. Bayomi as well.
Okay, for instance as well, from the agreement, you discover it says that the parties are aware that 24-inch pipeline is under construction to be completed in January 2010. And the agreement was signed in January 2010. Then, which comes first? Is it the agreement that comes first or the project, the pipeline project that comes first? You know something is absolutely wrong somewhere, which means there are several false representations in the agreement. There were no due diligence. There were no effective monitoring to ensure that what we append our signatures on are the appropriate thing. I think we need to watch out from all those aspects. I agree with Doctor's point that the judge has light a torchlight and has given us a mirror. We should go back and look back at our system and ensure that proper things are being done. There is monitoring, there is proper supervision, so that the right thing should be done at every time.
All right, let's come to you. During the process, while you were also, pushing for Nigeria not to, honor any kind of award and all that, was there a point when you were discouraged or afraid that this whole thing, this whole sham could sail through?
Naturally, with the arbitral award, by under the contract, it was definitely a worrisome point. The reality of the matter is that we are really lucky in the sense that first we got leave to challenge the arbitration award, and then we were able to take, first let's begin from even the point of refusing to pay. I think it's commendable that the government was bold enough and strong enough, bold enough and strong enough to be ready to challenge. That's number one. Because if they didn't take that step, the leave to challenge would not have been granted. That's number one. Then, when we got to the point of arbitral award, you can imagine the arbitration itself was a problem. And if we read the judgment, the judge also spoke about actually reviewing the power of arbitration and the way arbitral awards are granted, particularly in major cases that involves nations of this magnitude. So that's a problem. But there's another aspect of it. Our people, the peoples of Nigeria, we also have a role to play in bringing about appropriate government in this country. Because we have too much pressures on political appointees. Let us also come to that. Or even, look, you have a situation where you support a government to come into power, and everybody is pressuring you to go to that government to find something, even when you have a job. I'm a lawyer, I'm practicing law, I'm contented, I don't want to build an empire. I just want to be able to live my life, feed my family, send my children to school, all of which I have achieved. I have achieved all I want to achieve on earth. But now you support a government, somebody will say to you, oh, what are you getting? What do you want to? What do you want to? So the pressure of people on political appointees make them in some cases mad in their desperate desire for money. We cannot have a nation where the only thing that matters is money. Value no longer matters. The only person that matters is the person that has money. And when he has money, he can use it to win influence. And when he has influence, he can win it to get protection. Then our institutions, people must be ready to stand up for what is right. Unless you are able to stand up for something, you fall for just anything. In our nation, particularly our youths, some of us, our generation, we are disappearing. But what kind of nation is it going to be in future? Our young ones, all these Yahoo boys and so on and so forth, they must begin to rebuild their head to create a great nation. Our parents, their parents have sacrificed for this, and many of them. It is true that things are not as it is, but it is true that a lot of these parents have also made a lot of people like us 3 detentions, 1 for 1 year. We want a great nation because we cannot all live for Canada or live for America or live for Europe. So it is important for the peoples of Nigeria to make up their mind the type of nation they want. Do they want a great nation? If we want a great nation, those great nations, their citizens sacrificed for those nations to be what they are. So let us make the sacrifice for a great Nigeria nation.
Dr. Kenife, it's a bit embarrassing that somebody from a...
I like the idea of a special court for trying corruption cases. But equally, until you get there, we also need to deal with the issue of pre-hearing. Because in UK, you have this pre-hearing where all the objections are dealt with, there's an agreement on all the after exchange, after discovery. There's agreement, so you don't come and bring all these injunctions and no. After that pre-hearing, the judge will now give an estimate that the trial will be 2 days or 1 week or 3 days. And then when you come, the case is finished. Then there's a third one. I've had people that are saying that we should actually go for Crown Prosecution Agency. So why would EFCC do all the investigation, and then when it comes to taking the matter to court and all of that, you start having issues? So let's have an independent, like in the UK again. I mean, I've used that because I lived for 2 years in the UK. We have a Crown Prosecution Agency. You submit all your things there. They will look at them, and then once they're okay, then the case flies. So, some of those views is that, the problem now. We know the problem issues we have in the country. When you are both the the investigator and the prosecutor and all of that, and then it opens you up for all kinds of challenges. So these are just the three perspectives that I have.
Dr. Kogo, I was going to say, it looks a bit embarrassing that somebody from abroad can just look at you and say, let me give all of them money, they can sell the country, they can get me what I want at the highest levels of government, to get you to append your signature to a document that will indict your country or put your country into debt, running into almost $10 billion. It looks like a lot of people say Nigerians are smart, but when you look at that on the long run, it seems as if we could just be taken so cheaply.
We are the ones responsible. We are the ones that should really take care of our moral laundering, internationally and domestically. Let me stress about what I mean about this special anti-corruption court. All the 7 anti-corruption agencies in Nigeria, there should be government determination not to take their cases into our regular courts. This special court under section 230 to 304 of the Constitution, amendment should be made to institutionalize it there. It should be a court of summary trial. Instead of this inquisitorial, it should be the other way. In other words, once you are accused, the burden of proof should be on you. And it should be a court that should have time limit. And if possible, there should not be room for appeal. And it shouldn't be a court that should be subject of prerogative of mercy, immunity clause, or state pardon. And at the same time, these courts, if it is established, it should be in all the 6 zones. Because otherwise, if it's only one, the congestion of cases will be like our current Supreme Court, whereby if you file a case, probably if you are lucky, within 20 years, you get a date for you. Because there are only 2 rooms there in the Supreme Court. Or if you should go to the Supreme Court, then the Supreme Court should be radicalized. What I mean by radicalized is that it should be unbundled. There should be Supreme Court of Constitutional Matters, Supreme Court of Criminal Matters, Supreme Court of Commercial Matters, Supreme Court of Land Matters, Supreme Court of this and this and this. So that all the 24 common law subjects should have independent courts of specialization. Otherwise, you can never get a case dispensed within a period of 20 years. So if that one is done, and then government should lead by example. For example, there is no reason why the Federal Executive Council should turn itself into tenders board. Leave the Bureau for Public Procurement. 19 years after its establishment, up to now, you have not established the National Council on Private Procurement. It should be established. So the Federal Executive Council should be restricted to policy incubation and then calibration of performance of the execution of those policies. This is the essence of Federal Executive Council, not award of contracts. And then as much as possible, politicians should lead by example. As much as possible, reduce the flamboyance. If you see any traffic joint in any junction in anywhere in Abuja, you see siren coming, you discover that most people that are in uniform or that are privileged to have more cars with sirens, you understand, they don't respect traffic lights. Leadership should be by example. And as much as possible, try as much as possible to reduce all these issues of nepotism. Because there is nowhere in our laws, nowhere that it is said 6 geopolitical zones. It is an anathema. It is foreign to our law.
Citizens.
Yes, citizens of the Federal Republic of Nigeria. Once you sit there, they listen. Yes. And then, like I said, the president should be up and doing. It is there in your, whether it's 9-point slogan or 9 points agenda, it is there. Therefore, there is moral burden on you to act on it. So, we have touched the light for you now to see. The mirror is in your hand to effect the changes for the nation. Fight against corruption should start now. All cosmetic and symbolic type of the way we are doing it should be changed. There should be really convictions. How many convictions have we gotten? EFCC has been doing an excellent job. You know, you arrest the media, patriotic job. Today you will see the system beaming in all the headlines. So arrested, so. How many have ever been convicted? That is where the problem is. So we have to change the system. It is only a madman that will keep repeating one thing every day, and he will be clapping his hand and say he is succeeding. We are not succeeding in anti-corruption war. If we are succeeding, this should be a light of reflection so that we sit down. Get competent statesmen also to man the anti-corruption court. People that will not see giving them that position as judge of that court as any privilege. No. People that will look at it as pity themselves for taking the onerous responsibility of national redemption. This is my own take on this, sir.
Professor Ike.
Yeah, I think it's not quite Uhuru yet because they have a right of appeal. So don't think that is the end debate. I mean, we know that they will be standing on very, very weak ground. But secondly, the judge is ready to hear the cost. There's going to be a hearing for them to decide, what they are awarded. They will have to go out. If you get the cost awarded to us, then we'll have to go to the Channel Island, all those islands where they see whether I can get anything. So we're not done with EFCC yet. You're going to find the money to pay for the bills. Well, those are just the two observations.
All right, EFCC, before I let you go, of course, we've seen the quantum of job, at least, that you have done so far. But this is not the end. Like many people have said, it seems as if the P&ID is the beginning. Like people will say, it's a watershed moment in our history in terms of these contracts that we've seen. Many of them that may have, gone away and people have smiled to the banks and traveled abroad and all that. But this is one that we have, say every day for the thief, one day for the owner. We've gotten one. Definitely. So, what are we standing on and moving forward, especially from your department or your unit? How do we begin to, raise these red flags?
In the EFCC, we have the Special Investigation Unit. We added P&ID to it, but going forward, it should be more of a Special Investigation Unit that should be responsible in looking at and handling some of these special kind of cases. And the unit has well-trained personnel, and they are always on their feet, ready to do whatever it takes. Because for the P&ID, yes, it has been 4 or 5 years, but it has been 5 years of tremendous work. It has been 5 years of extensive research. It has been 5 years of looking at every financial document, statements of account, requesting for every statement of account that was needed of every individuals and companies to be able to analyze forensically and juxtapose to arrive at the decisions and evidence that we're able to. I remember that after the conviction in the Federal High Court in Nigeria, Justice Ross Cranston, at a point, he said he wasn't very sure of the conviction. But when the evidence was placed before the court and he reviewed the evidence, he believed that a tremendous job has been put into that exercise within a period of 15 months. We have been able to do that within a period of 15 months.
I think he even mentioned EFCC in the judgment.
Definitely. Yeah. So it was an unprecedented exercise that was carried out. With this, it's just a walkover in any other assignment that will come our way.
Sorry, I just want to ask EFCC. Is it not possible for EFCC to establish and coordinate this whistleblower that is talking about?
Yeah,
I know
definitely.
the powers granted to you over, financial crimes and so on and so forth is very expansive.
Yes.
Is it not actually possible? Because if we're depending on government to establish it, like you said, it may
there was a
take quite
whistleblower
while.
policy under the immediate past administration, especially the first under the former Minister of Finance, Adeosun, and they were also supposed to put in some.
The problem it was not institutionalized.
Yes.
And it was supposed
there is no immunity, no protection of the blowers, and no certainty that the social percent will even go to the blowers.
Yes.
That's what I'm saying. There was incentives supposed to be added to it. But Dr. Abayomi, you've said a lot about this. But are you heaving a sigh of relief, especially on this one? But moving forward, what are your comments as we round off?
Well, like I said, one of the areas we need to focus on is building institutional integrity. That's number one. Building security for the future. For example, I was speaking about that lady who, out of frustration, had to leave government. I'm sure there are so many examples. Now, we're talking, yes, there's tremendous corruption in our land. But the reality of the matter is that there are still lots of our people that are willing to stand up for this nation. But if we're going to stand up for the nation, the reward of protection is essential. It's like we went to jail in the struggle for democracy, in my case, 3 times. One for 11 months, the third one in just prison. But eventually, we got democracy. And we are happy, we have freedom. So if you are able to stand up, and you are sure you get protection for standing up for this nation. But if you have a situation, because if you look at our situation, the leaders, in our the tendency and the tremendous power vested in the leader for an appetite for mischief is too much. We have a situation where the Accountant General of the nation has become the thief of the nation. You have a situation where somebody who is supposed to manage pension becomes the pension itself. And because in each of these instances, they are the leaders. So we must find a way to contain and control leadership itself. We cannot have a situation where the leader is above the law. In our nation, leaders of institutions, leaders of government, President Obasanjo once told me that there was a permanent secretary that had 59 houses in Abuja, a permanent secretary that had 59 houses. So when you have a nation where the institution is under the influential, the leader or whatever, instead of the person subject itself to the institution, we've got a problem. So we need to build institutional integrity to curtail and contain the terrible appetite of leaders. Then we need to improve on poverty. Let us also remember that. Because if we have a director that is only making maybe 500,000 and he has to send his children to school and he has to build a house and he's thinking of his retirement, it will be difficult. So there must be ways by which we can support, either by President Tinubu is trying to do something like that, to make sure that, you can take a loan, mortgage of some sort, to build a house, take loan, to go to school, and so on and so on. We must find facilities to support people in government so that their anxiety, natural anxiety, because look, you cannot have a situation where you have your colleague that is sending his children to school and you can't send your child to school. Definitely you will find a way, because your children will ask you, how about that man over there? So we must also find a way.
Somebody was just perhaps buzzing me that there's no school that they are paying $8 billion.
Yes. So institutions, education, and so on and so forth. These are all the things that I think are essential.
Thank you so much, Dr. Minasaku. Final words.
Another thing in summary is that I commend the dexterity of the EFCC. But more than that, you should continue to go into alliance and partnership with all the other anti-graft agencies, especially the Interpol, the Egmont Group, all those international agencies continue to maintain the distance, and then keep maintaining peer review comparative something with the other agencies within the country, and then the government should listen to all the suggestions we have given in establishing the anti-corruption court and in institutionalizing whistleblower policy with a law of the National Assembly.
That has been Tuesday Live. Many thanks to Umar Hussein Babangida, Head P&ID Unit of the Economic and Financial Crimes Commission, EFCC. Thank you for coming.
Thank
and
you,
congratulations on this feat. Hopefully we'll see more.
Thank you.
And of course, Dr. Tunji Abayomi, constitutional lawyer, a patriot who has been there, really pushing the Nigerian cause. Thank you very much for coming. Dr. Mina Sarakugu, Umar, of course, international affairs analyst, a constitutional lawyer. Thank you very much for being a part of today's program. And Professor Ken Ife, as usual, for your very eloquent and deep contributions. Thank you very much for being a part of Tuesday Live today. Thank you very much for being there, watching this edition of Tuesday Live. We've been discussing the judgment on the P&ID in favor of Nigeria. Hopefully, what you are also doing is in favor of Nigeria. My name is Fisaya Ogunfi. Thanking you for staying tuned. All the best. Enjoy the rest of the day. Good morning.